Hey everyone, and welcome to this exam prep explainer. Today, we are breaking down a massive topic, the International Bill of Human Rights. We're going to give you the exact high-yield structure you need to absolutely ace your upcoming tests. So if you've ever felt, completely overwhelmed by international law, you are definitely in the right place. We're going to make this incredibly clear. Here's a quick look at our roadmap for today. We'll start with the International Bill of Rights, then unpack the UDHR framework, dive into binding treaties, look at domestic integration, and finally, wrap up with some landmark case laws that you absolutely need to know. All right, let's jump right into part one, the International Bill of Rights. So, emerging from the ashes of the Second World War, the global community desperately needed to fill the constitutional gap left by the 1945 UN Charter. The Charter mentioned rights, sure, but it lacked a specific, detailed list. Now, here is a massive exam tip right out of the gate for you. Do not fall for the classic trick question here. The International Bill of Human Rights is not one single written document. It's actually an authoritative collective term describing a tripartite framework of multiple legal instruments. Specifically, it includes the Universal Declaration of Human Rights, or UDHR, the International Covenant on Civil and Political Rights, the ICCPR, the International Covenant on Economic, Social, and Cultural Rights, the ICESCR, and of course, their optional protocols. Moving on to Section 2, let's unpack the framework of that first major piece, the UDHR. Let's look at how all of this builds into the Universal Declaration of Human Rights. Adopted in 1948, this is often hailed as the permanent Magna Carta of all humanity. And to ensure it wasn't just some Western-centric document, it was drafted by a globally diverse committee. We're talking chaired by Eleanor Roosevelt, featuring brilliant minds like René Cassin of France, Charles Malik of Lebanon, and P.C. Chang of China, all to reflect true worldwide consensus. Now, the resulting document isn't just a random list of nice ideas. It's deliberately layered. This structural matrix categorizes the 30 articles of the UDHR all the way from foundational pillars up to collective responsibilities. Seriously, take a mental screenshot of this table right now. Memorizing these specific article brackets will practically guarantee you points when you're asked to contrast first versus second generation rights. Articles 1 and 2, those are your baseline foundational pillars of liberty and equality. Articles 3 through 21 cover your first-generation civil and political rights, things like the right to life, fair trials, and freedom from torture. Then, Articles 22 to 27 shift gears to second-generation economic and social rights, like the right to work, education, and a basic standard of living. And finally, 28 to 30 wrap it up with our collective duties to the community. Okay, Section 3. Let's talk about binding treaties and enforcement mechanisms. So because the UDHR was passed as a General Assembly resolution, it actually began its life as a non-binding declaration. It was just soft law. It needed to evolve into hard treaty law to actually hold weight. Well, the Cold War geopolitical climate at the time basically forced the UN to split these abstract moral rights into two entirely separate binding covenants in 1966, which finally entered into force a decade later in 1976. But why the split? Well, Western nations were demanding the immediate execution of civil liberties, while socialist and developing states pushed back, arguing that socioeconomic security had to be the top priority. Now, this comparison right here, this is pure exam gold. You're pitting the immediate execution and absolute non-derogable rights of the ICCPR, like the right to life and freedom from torture, which literally can never be suspended, even in national emergencies, against the resource-dependent flexibility of the ICESCR. But you have to remember, even the ICESCR has an absolute baseline minimum core obligation. States simply cannot use poverty as an excuse for complete inaction when it comes to things like basic food or primary health care. Here is another highly actionable tip for you. If you're writing an essay on this, you absolutely must use the exact legal phrase, progressive realization, when you're describing how states have to fulfill socioeconomic rights over time under the ICSCR. Contrast that directly with the immediate respect demanded by the ICCPR. I promise you, examiners are specifically scanning your paper for that exact terminology. But look, treaties are practically looseless without enforcement, right? To ensure states don't just ignore these agreements, the optional protocols grant actual enforcement mechanisms. They provide the legal teeth. The first optional protocol to the ICCPR is huge. It actually allows individual people to completely bypass exhausted national legal systems and file complaints directly with the International Human Rights Committee. The second optional protocol to the ICCPR mandates the total abolition of the death penalty. And finally, the optional protocol to the ICESCR allows for international inquiries into gross systemic socioeconomic violations. All right, Section 4,
customary law and domestic integration.
Let's look at the Supreme Law of India as a really prime example of domestic integration. The framers of the Indian Constitution heavily borrowed from that global framework we just talked about, and they cleanly divided it into two domestic chapters. Part 3 holds the first-generation civil and political rights, making them directly justiciable through Articles 32 and 226. Part 4, on the other hand, holds the second-generation economic and social rights, which are non-justiciable, but still completely fundamental to governance. However, and this is a big however, through decades of judicial activism, the Indian judiciary has effectively dismantled the wall between these two parts to constantly expand the scope of fundamental rights. Okay, before we hit the case laws, lock this into your memory. Always make sure to mention that the UDHR's core provisions have matured and crystallized into binding customary international law today. What does that mean for your exam? It means they operate completely independently of the 1966 covenants. Even if a state never signed those treaties, they are still universally bound by customary law. All right, moving to our final section. Section 5, Landmark Human Rights Case Laws. For these cases, we're going to use a modified IRAC method: issue, rule, application, conclusion, focusing heavily on the facts, issues, and judgments, because these are ultimate exam gold mines. Our first case is an international one, Filartiga v. Pena Irala. So picture this. In this U.S. case, a 17-year-old Paraguayan citizen was tortured to death by a foreign police inspector down in Paraguay. Years later, the victim's sister actually found that very inspector living in the U.S. and sued him under the Alien Tort Statute. This raised a massive legal issue. Does a domestic federal court even have jurisdiction to adjudicate state-sanctioned torture committed abroad by foreigners? The U.S. Court of Appeals stepped in and declared that the absolute prohibition of torture is a customary norm. By labeling the torturer hostis humani generis, which translates to an enemy of all mankind, just like the pirate and slave trader before him, they brilliantly proved that domestic courts can absolutely hold foreign abusers legally accountable based purely on universal, customary international law. Next, we shift over to the Indian context with Maneka Gandhi v. Union of India. When a prominent journalist had her passport arbitrarily impounded, supposedly in the public interest, without any hearing or even a statement of reasons, the Indian Supreme Court was forced to step in. They had to decide a crucial issue. Does the constitutional phrase procedure established by law actually allow for arbitrary state action that restricts personal travel abroad? Exam tip for this one, you always want to cite the Golden Triangle Doctrine here. The court ruled that Articles 14, 19, and 21 are interconnected. They essentially said that any law restricting liberty cannot be arbitrary. It has to be just, fair, and reasonable. This historic decision successfully domesticated ICCPR civil liberties directly into the Indian system by requiring a much broader standard of substantive due process. Our third landmark case is Olga Tellis v. Bombay Municipal Corporation. So after a massive sweeping drive forced the eviction of thousands of pavement and slum dwellers in Bombay without any resettlement plan, the dwellers argued that eviction would literally slide them into starvation. The Constitution bench faced a profound, almost philosophical question. Does the justiciable right to life under Article 21 physically encompass a protection for the right to a livelihood? The court firmly ruled yes, the right to livelihood is an inseparable facet of the right to life. States absolutely must follow reasonable procedures, like giving notice and providing fair hearings. This specific case is essentially a masterclass in bridging the gap between generations of rights. It takes a second-generation economic right directly from the ICCSR framework and creatively reads it right into a first-generation civil protection. And our final landmark case today is Vishaka v. State of Rajasthan. Following a truly horrific crime against a social worker and highlighting a total absence of enacted domestic legislation in India regarding workplace sexual harassment, a collective of NGOs filed a class action petition. The core issue was this: can constitutional courts step up and utilize international human rights conventions to fill a deep legislative vacuum within domestic law? The resulting Vishaka guidelines proved that, yes, they absolutely can. The Supreme Court bypassed the silence of the legislature and directly integrated principles from the UDHR and CEDAW, that's the Convention on the Elimination of All Forms of Discrimination Against Women, to create binding domestic guidelines until Parliament officially acted. This firmly established the ultimate authority for the adoption of international treaties, proving that global covenants can be directly integrated to secure justice when national laws are totally silent. So, to wrap up this explainer, I want to leave you with a final, kind of provocative thought on international integration.
If global declarations can just step in and essentially rewrite domestic fundamental rights without a direct parliamentary vote, who truly creates the law of the land? Ponder that as you prepare for your exams. Study hard, utilize these specific structures, and go maximize that score. You've got this.